Before we argue breach, we need to be clear that a contract was actually formed. Everything turns on offer, acceptance, consideration, and intention to create legal relations.
Agreed. Let's start with the offer. The key question is whether the statement was sufficiently certain and definite, rather than a mere invitation to trade.
Exactly. Advertisements, price lists, and displays are usually invitations to treat. Pharmaceutical Society versus Boots still guide us there.
But here, the wording was specific and left nothing open for negotiation. That points towards a unilateral offer, similar to Carlill and Carbolic Smoke Ball Co.
Which brings us neatly to acceptance. Was there an unqualified mirror image acceptance, or did the response amount to a counteroffer under Hyde versus Wrench?
The reply didn't vary the terms at all. Acceptance was communicated clearly and crucially. It occurred before revocation, so no issue here.
What about the mode of acceptance? If the postal rule applies, acceptance would be effective upon posting, per Adams versus Linsell.
True, but the parties were communicating by email. That suggests acceptance takes effect upon receipt, following entries and miles far east.
Fair point. Moving on to consideration, we need something of value in the eyes of the law, even if it's not adequate.
But it must not be past consideration, fortunately. The promise was exchanged contemporaneously, so re-MacArthur isn't a problem.
Nor is existing legal duty an issue. The promisor went beyond what they were already obliged to do, satisfying Williams versus Rafi Brothers.
Finally, intention to create legal relations. In a commercial context, there's a strong presumption that such intention exists.
Yes, unlike domestic agreements under Balfour versus Balfour. Unless there's express wording to rebut it, the presumption stands.
So, taken together, a valid offer, proper acceptance, sufficient consideration, and clear intention, contract formation looks solid.
Which means the real fight isn't formation at all. It's whether the terms were later discharged or breached.
Exactly, but formation, on that front, we are on very firm ground.